All right, I've got Melissa Yoest today. She's an estate planning attorney. I also know that you're in practice, that you specialize in employment and business law.
Yes.
It's excited to have you and just learn a little bit more about estate planning and talk to you about it. Tell us a little bit about your background and where you come from and how did you get into estate planning, being an estate planning attorney?
Absolutely. I'm happy to be here.
All right.
Thank you for asking me that. So how I got into estate planning, it all derived from my personal childhood experiences. So my father passed away when I was 10, and that was my first encounter with death.
Oh, wow.
And so when he passed away, he didn't have an estate plan in place, but he was married to my mother, and they were on the title jointly with everything, with the house, with the bank accounts. And so we actually didn't have to go through the probate process, didn't have to go through the court system. So that was kind of my first encounter with death, right? So I didn't really see any legal side of that.
So they had joint tenancy on the title?
Yes, correct.
Last person gets the home.
Yes, that's how it worked. When I was 16, my grandmother passed away. And when she passed away, she actually had an estate plan in place. So it was pretty detailed. She had a house. She wanted it sold, divided among the 3 kids. It was another positive experience with the exception of my grandmother passing away because we didn't have to go to court. We didn't have to go through that system. I didn't have to deal with any family members bickering or fighting because the trust was very detailed and everything that she wanted happened.
Yeah.
So it was actually another positive experience with the exception of my grandmother passing away.
So talk to us about a trust. What actually is a trust? It's almost, I would say, kind of a blueprint for your family, right? When you pass away.
Yeah, absolutely. So it directs what you would like to do with your assets when you pass away. But a trust can also be utilized while you're still living as well. It deals with incapacity. So dealing with those issues that when you can't make decisions for yourself, you appoint the particular people in order to do it for you. And it also lays out what you would like to happen in that event. So it helps with distribution and just outlines your wishes, and it allows you to have control even after you pass away as well.
We were talking about this right before we went live, but I was telling you about the statistics actually. It's like 70% of all people don't have a will or a trust. Why do you think that is? Why do you think that most people avoid that?
Well, I think some people don't know what it is. They don't know what an estate plan is. They don't know what a will or a trust or the benefits that it can do for them. Or maybe they think it's just for the rich. It's just for the wealthy. Maybe they don't realize that it can be for them as well. The other reason what I would say is that I think people just put it off. They're like, I'll get to it. We'll get there. Or I'm not old yet. I don't have to worry about this.
Sure.
So I think it's the mentality of them thinking like that.
Here's a good thing to touch on I think you're right. I think most people think it's for the rich, but it also could just be for the average person. And I think what most people think is when they're getting these things is like, well, how much is it going to cost? And I want you to talk about what the minimal cost is now versus going through a process of, let's say, probate, which that would end up costing you. So, a basic trust would cost somewhere if you have an estate that is not complicated, what would something like that cost?
Well, it's going to depend on the attorney and what they offer in their services. So someone can quote you a low cost, but it's not going to include everything that you need if something were to happen to you. Sure. So I caution when people are looking at costs to see what the plan actually entails and what it actually covers. So I would say a fair range for an estate plan could probably range anywhere from like 35 to $9,000. It really does. The range is so large.
I've heard it really just depends on the complication of the estate.
Right. Yeah. So the complication of the estate, it's not necessarily how many assets you have, but it's usually what you want to do with those assets. But also if you have an enormous amount of assets, it may bring up the cost. But like for the regular people around here, it just kind of deals with what you would like to do with your assets.
I think a lot of people put it off because they say, oh, it's $2,500 and I can't really afford that. But I don't think people understand how expensive it's going to be for you if you don't have that trust in place.
Right. Absolutely.
For your entire estate will go through a process called probate, right?
Correct. And probate, it's average the cost about 5% of your total gross assets.
Right.
So if you think about how much your house is worth today, think about 5% of that. And I know you own more than just your house. Yeah. So that's kind of just a rough estimate.
Let's say a $500,000 house at 5%, that's $25,000.
Right. Absolutely. And so you're telling me that, we call it $3,500 to $9,000 is a lot. Well, go through probate. We'll see how much it really costs.
So getting into a trust, what does actually a good quality trust entail? I mean, what would you put in there? How would you actually structure that trust?
Of course. So one thing to think of is that sometimes people are like, oh, let me do my trust myself. I know what I want. I know how everything wants to be distributed. And that's great. You know, you've covered everything. Like you want this to go there. You want that to go there. But what you don't anticipate are the things that can go wrong.
Sure.
And a good trust anticipates everything that can go wrong. And that would be a sound trust that can anticipate all these things if they were to occur, whether it's family conflict, whether, incapacitation. A thorough trust actually attributes different sections of the trust to each of those things. So that would be a comprehensive trust.
Here's a good question for you. Most people think I have a will. That's gonna protect me. I'm good to go. Explain what happens if you just have a will in the state of California and how that process works out for you. I mean, do you still have to go through this?
Right.
Well, I'll let you explain it. So.
Yeah, so that is a common misconception. I got a will, I'm good, right?
Yeah.
Well, a will still goes through probate. And so probate, as we just mentioned, the cost of probate, you're still paying that. A will doesn't circumvent that. So a will, at least it tells the court exactly what you would like to do with your assets. Rather than probate, what happens to your assets is dictated by the state.
So a will, it protects you, but it just gives the judge, let's say, a kind of an outline of how you want things done. What's a good question I get all the time is what actually is a valid will, right? Mm-hmm. I have a will. I found the will in the back closet, but it's not signed or it's got an X on it. You know, it's a holographic will. So can you explain actually for folks out there, listeners, what actually a good solid will would entail, and does it need to be validated by or signed by 3 people, 2 people, or who has to witness it?
Yeah, so a will needs to be witnessed by 2 parties, like two uninterested parties. So they can't be actually mentioned in the will or receive any benefit from it.
Oh, they can't be mentioned in the will.
Correct. Yes. Yeah. So these witnesses have to be completely disinterested, and they actually have to see the signer sign the will. And so these are important criteria because, again, people contest wills all the time, or they find a note somewhere saying that. Yeah. So we literally just had a case like this that someone, the wife of the person who passed away had written something, and then the person who passed away signed it. But it ended up not being valid because it was all the wife and the wife's intention, and it's the wife's handwriting. The only thing that person did was sign it.
So I've had incidents where people come to me and say, oh, they were passing away, they were on their deathbed, let's say, and they actually wrote up a will, but he never signed it, or it just wasn't, witnessed by 2 people. So that would be invalid. That'd be invalid.
He would at least have to sign it. Correct. Mm-hmm.
Okay.
And so holographic wills, sometimes they can be held up in court. It just depends on the circumstances. If he's on his deathbed, you're going to have issues with mental incapacity. So
sure.
We can go in that whole story as well.
We were talking about power of attorney. I think people take that power of attorney, they take it on beyond what that actually power of attorney document can do. So can you explain what a durable power of attorney and a power of attorney, what those documents do for folks?
Yeah, so durable power of attorney comes into effect when you're incapacitated. So while you're still alive, it has no bearing on whether you pass away. And it provides the people that you appoint to be able to handle your financial assets and be able to make decisions for you on your behalf.
Sure.
And the difference between that and a power of attorney would just be the powers that go along with it. So whatever's in that durable power of attorney, they're meant to be a little bit more robust,
sure.
Rather than just a regular power of attorney would be directed only at finances. So it all just depends on what powers are laid out in each of those documents. That's how it would be effective.
So you would, let's just say for a power of attorney document, you could just pinpoint it to be like, I want this sold or I want this done. You could say a specific reason why you want up this power of attorney. Like, for example, I want you to have the ability to sell my house. I'm going to have you just sign this power of attorney document just for that, right? Correct.
Yes. You can be as specific or as broad as you would like. Yes.
Okay. And then the durable power of attorney just goes, it extends when you're incapacitated. Is that how that works?
Well, even a regular power of attorney could be effective when you're incapacitated. So durable, it just has broader powers. So again, it'll be specific to whatever is written in that document.
Talk to me about what a pour-over will.
A pour-over will is in the event, so usually it's associated with a trust. And so if you have a trust, you also have something called a pour-over will. So in the event something did not get put into the trust, a pour-over will govern, and depending on what it is, it may go through probate. So for example, if you had in your trust that you wanted all of your property to go to your nephew, right?
Sure.
And everything was put in your trust at that time, but then later on you bought something else, right? And you forgot to put that into your trust. So now we have something called a pour of a will that we create with your trust document. In that pour of a will, it says, I want everything to go to my nephew, not my kids, right? And so although that house didn't actually get put into the trust, the will govern, but it will go through probate, but at least it will tell the judge that they want the house to go to the nephew, not the son. Does that make sense?
It does, okay. Actually, it does. That's why we need attorneys like yourself, because it can get complicated. Healthcare directives. What are those?
They come into play when you're incapacitated, the person to make medical decisions on your behalf. And so, again, it's an incapacity. Again, you have to be alive for healthcare directives to work. And usually you want to pair them with HIPAA waivers as well. So they provide those people with medical information to make decisions on your behalf.
So explain what a HIPAA is, or a HIPAA waiver is.
Yeah, it's a release of medical information to designated individuals. So ultimately, you want to use those in conjunction with each other.
Because not any person can just go get your medical records, right? They're sealed.
That is correct.
So the HIPAA actually gives them the ability to go and look at your medical records and decide maybe even further what needs to be done.
Right.
In terms of your capacitation. Sorry.
Yes, and it also allows a hospital to disclose medical information about them as well.
So I'm your client, and I've got assets, right? And how would you advise me to put a trust together? What assets go in the trust and what assets do not go in the trust? How would you look at my assets and say, okay, this should go in there and this should not go in there? How would you advise a client?
Ultimately, we want to associate everything that you have with the trust, whether we're actually putting it in and retitling something or whether we are assigning an interest to it. So we want to make sure there's some type of association with the trust because we want to make sure that no assets go missing. So if you have a home, if you have stocks and bonds, we actually retitle those assets and put them directly into the trust. Personal property, like this table, for example, it doesn't have a title on it, but we can pull it into the trust by way of a contract. So we acknowledge that personal property is also tied into the trust as well. Other things like retirement and life insurance, we actually don't retitle those accounts into the trust, but we want to make the trust the beneficiary of those accounts to make sure that whenever you do pass away, that money flows directly into the trust. If you own a business, we want to make sure the business interest is assigned to the trust as well, because we don't want to have to go through probate for your business because you forgot to handle that. Right. So ultimately, everything that you own is going to be associated with the trust one way or another, whether we're putting in or whether we're assigning an interest to it.
In my line of business, let's say someone refinances their home and they take it out of the trust in order to refinance, but they forget to put it back into the trust. Is there anything that you can do as an estate planning attorney that would help them, and they pass away, anything that you can do that would show that actually meant to have it back into the trust?
Oh, so you're saying when they refinance the home, it ended up getting changed out of the trust name and into their personal name? Okay, perfect. So there are things that we can do that involve the court. So remember, the reason why we put a trust together is because we want to avoid probate. We want to avoid the court. Sure. But if for some reason you forgot to put it back in there and you've already passed away at this moment, we can do something called a Hegstad petition in court to be able to try and demonstrate to the court this was the true intention. But again, it does involve the court process. It involves the probate process, which was something we were trying to avoid altogether. So just make sure it doesn't happen.
If someone wants to start, where is the first step that they can, by contacting you, what is the first steps that they can do to bring say their assets or information to you to put a trust together? What are some of the basic documents people need to bring to you to start a trust?
Yeah, so usually we start off with, the deed to their home, bank account information, statements for retirement, life insurance, any other documentation of any stocks and bonds, tax returns. Ultimately, we're just trying to get a big picture of what they have and make sure, like I mentioned earlier, that everything ends up being associated with the trust. A lot of times people never list everything they own in one place and the approximate value of it. And people don't realize how much they really actually own. And so when we have that consultation, I kind of, I lay it out for them. And you actually own more than you really think. Right. So people are really surprised at that moment. But yeah, so at the bare minimum, putting together those documents will give us a good financial picture of where they're at.
Let's talk about that nasty word probate and what that entails. So why would someone go through probate? Annie, can you explain what probate is?
Yeah, so probate is the process of retitling assets when you pass away. So if you passed away with something titled in your name, somebody is going to have to take it out of your name and into someone else's. And the way we do that is a court order. That is why people go through probate.
What are some common mistakes that most people make that unintentionally force an estate into probate? What do they do unintentionally that could cause someone to go into unintentionally?
Unintentionally? Well, I guess I'm not entirely sure what you mean unintentionally. So if you have a trust, you get to avoid probate. And as I mentioned earlier, it's because you go through probate because you're retitling assets that you passed away with in your name. Sure. And so the way trusts are able to avoid probate is because we are retitling those assets while you're still alive. And so that is the reason why you get to skip probate altogether. And so if you don't have a trust, you didn't retitle those assets while you're still alive, you're going to go through probate. That's why I'm not really sure about the unintentional part.
Sure.
And so if you're going through probate, that means, probate's very public. Everyone's going to know what you have, who passed away, who gets what. So everyone is all in your business.
Yeah.
And then also, like we mentioned, it's very costly. We gave that number. It's about 5% of your total gross assets. And so probate, they have something called statutory fees. So the fees are dictated by the state, by the law. It's not something that one person charges more than the other. It is what it is.
I get that question all the time. What is it going to cost? What does the attorney charge to go through probate? And it's statutory, right?
Right. So all the attorneys will charge the same thing because it's dictated by law. It's actually a percentage based on the total amount of your estate. So it's based on like 4% of the first 100, 3% of the next 100, 2% of everything up until 800,000, and then 1% thereafter. So that's how come we average about everything. Everything that plays a factor in probate is about 5%. So that's like the attorney, that's the administrator fees, that's the appraisal fees. So just everything that can go into it. That's our ballpark figure. Can be higher, can be lower. Again, it's based on your estate. So and also probate just takes a really long time. Yeah. So usually it's hitting about like 18 months to get through probate.
And that's a seamless one.
It's seamless. Yeah, that's seamless. No hiccups. That if you have a house, selling it could take longer. Sure. If someone's contesting it could take longer. If someone finds a will, it could take longer. Yeah. So these are all things that will just drag out the probate process.
We're here in Sacramento County, and I know they're just super backed up. I mean, the court system is, it takes at least a month to get a court date to file the petition.
45 days.
45 days.
Yeah, that's the bare minimum required by law.
45 days. And so what is the first step in filing? It's called filing the petition to probate, right?
Yes.
And is that something that you would do at your law office?
Yep, absolutely. If the client retained us, we would file that petition for probate. And then we'd send out notices. So we'd have to publish a notice in the newspaper, and that has to run for 3 consecutive weeks. To notify everybody that somebody passed away. And if you have a claim, that's your chance to submit it. So all your creditors and everyone out there.
Isn't it kind of weird that it's old school now where they're still got to put it in the newspaper?
Right. But you would be surprised how many. Well, I mean, there's companies that literally just read the newspaper for that.
I agree.
So it's not missed, but it's definitely utilized, unfortunately.
So you filed the petition to probate. What's next? I think it would be the court confirmation. Would you show up for the court confirmation? And what is that?
Oh, like the order appointing?
Sure.
Yeah. So once you get that hearing 45 days out, you get the order for letters of administration in order to appoint who you want the administrator to be. So it's the same person filing that petition who's requesting those, what they call letters of administration, to be able to carry out the terms of the estate in order to facilitate everything.
I like to say it's like a permission slip, basically. It gives you the permission to now administer the estate. Now you can go talk to the bank. You can go look at the assets in the bank accounts and things of that nature.
Yes.
Kind of going back here, I've got funny stories where, they've some family members been put on the bank account, like as a joint account. And those assets have been, let's just say, taken out. And some of the family members are going, where's that money go? I guess people don't really understand or know that if you have a joint account, that money is just as much theirs as it is yours.
Absolutely. Subject to the same things. It does not go through probate if that person is still alive. And if that person gets divorced, half of that goes to there's a lot of issues with that.
Yeah.
But yeah.
And creditors can come after you too, right? Creditors, if that person that's on the joint account has bad credit, they could probably come after your money. So, what is the difference when you get in court confirmed? What is the difference between full authority and limited authority, and why would the judge give you either or?
So full authority just essentially grants you all the powers to be able to facilitate the estate, to make, to be able to buy and sell things, to be able to handle everything so you can get ready for distributions. Limited authority is, it's very specific on what you can do, or you need the court's permission to do each and every single little thing. And so,
which could take forever.
Yes. So every time you wanted to do something, you would have to
petition the court.
Petition the court, request permission in order to do it. And so that just kind of depends on the circumstances. If there's usually no issues, then we always request full authority. But sometimes the court may limit the authority just depending on, the circumstances surrounding it. So sorry, there's no clear answer with that one.
No, it's okay. And a lot of the times I see on the petition to probate, or they check the IAEA, Independent Administrative Estate Act. Talk a little bit about that and what that is for the administrator. What powers, kind of gives them broad powers, right?
Right. So it's similar to full authority and to be able to order to administer the estate.
In your line of work, when would someone get or use a spousal property petition?
Spousal property petition. I can't say that I've done that, so I don't have an answer for you. I apologize.
It's okay. I've seen those where, you got a joint account, or, there's only one person on title, and or the kids sign off on, that the mother wants the home. So the beneficiaries will sign off and just, I've seen where they do a spousal property petition.
Okay. So, but they're still going through probate with their.
Yes.
Okay.
Yes. It's just kind of like, it just, it expedites the process for the spouse.
Yeah. So the beneficiaries, so the children in that situation can disclaim any inheritance at that particular time in order to give it to the spouse.
Right.
Yes. So they're absolutely able to do that. So I guess they can do it via the petition. We do it in the distribution. So I guess it just depends on which way they handle it.
Oh, really? I didn't know that. Big question I get too is, how do creditors get paid? And what is the order of creditors? How do they get paid? Right. Right.
So the most not popular, but the most common that we see is usually medical entities. So when the person passed away, they were in the hospital for a really long time, and now there's medical bills that are outstanding. And so that's the most common one that we see. So when we put that notice out that someone has passed away, they will attach a lien to the probate case in order to make sure that they get paid. And so the creditors do get paid before any beneficiaries get paid. And so, if there's only enough money to pay the creditors, then so be it. That means there's no money for the beneficiaries. So it's really unfortunate in that, as in who gets paid.
So Uncle Sam would get paid first, let's say.
Absolutely. Always gets his money.
Uncle Sam gets his money first.
Yeah.
And then it kind of goes down from there, right?
It goes down from there.
And then it goes down from there. What is an EIN number, and how does that associated with estate?
Right.
Does that take the place of?
Yeah. So once you get those letters of administration, once the court gives you authority, you need to sign up for an EIN number in order for the estate. Because even the estate has to file taxes as well. Again, Uncle Sam always gets his money. So there's a couple different taxes that need to be filed when someone passes away. First, the taxes for the previous year needs to be filed for the individual. And then you're also going to notify the IRS that the person also passed away. And then there's taxes for the estate itself. Because during the time that the estate is opened, it could possibly generate income. And then that income would need to be recorded on the tax return. That's what the EIN is for. So a trust or the estate operates as an entity at that point.
Would you recommend someone that is personal representative, would you recommend them getting an accountant to actually go through that and pay the taxes that are owed? Or
it can definitely be helpful, but whether or not they need one would depend on the amount of the estate. If it is a small estate, I wouldn't necessarily recommend one, but if it was a large estate, it's definitely better to have someone else handle it.
Professional, right?
Correct.
question I get a lot of times too. It's kind of a weird thing that the court has. It's called a probate referee. What are those? What is it actually, a probate referee? And what do they do?
They don't referee sports, I'll tell you that.
Exactly.
Everyone's like, what's a probate referee?
Why do I have to pay that guy?
Right. Yeah, we all have to pay him. So ultimately, they're the ones who dictate how much something is worth. So they do the inventory and appraisal. They're the ones who say, okay, your house is worth this much. Or these bank accounts are worth this much. Debatable why we need them, I don't know, but
yeah, the government has them.
That's the process, and so we follow the law.
They're like an appraiser, let's say.
Yes,
they're like an appraiser.
But keep in mind, your house still needs to be appraised if you sell it.
I've gotten that too. Yeah. One of the things I like to tell people is they go back to the date of death, right?
Right.
So in terms of selling a home, well, my home is worth, depending on the market, it could be worth more, it could be worth less, and some people file years later, right? And the market has changed.
Right.
So it could have been worth $50,000 more back at the date of death. So I usually have to explain that to them that the probate referee is going back to date of death.
Correct.
Right. So it's just interesting. I wrestle with that all the time.
You're like, it's not worth that
much. One of the big documents for me that I have to wait for, or for you guys to send out, and maybe you could tell the process here, is notice of proposed action. They're called the NOPAs. We call them NOPAs.
NOPAs. Okay,
Yeah.
I haven't heard that one before, but I might pick that up now.
Yeah. Notice of proposed action. What are they? What do they do?
Ultimately, it's telling everybody that, hey, I'm going to sell this house for this much. If you have any objections, let me know.
Yeah.
That's ultimately what it is. And so you have to make sure that all the beneficiaries have the right to voice their opinion if you plan on selling a house.
So all the NOPAs go out to all the beneficiaries, and they all have to sign off.
Yep.
How many days do they get to sign off or contest?
Ooh, I don't know the answer to that question.
It's 15 days.
15 days. There we go. 15 days. You know what? So a lot of the uncontested cases, we get people to waive these notices.
Yes.
So that's why I'm
Yeah. Normally when you got a holdover, or someone that doesn't want to sell the property, or someone that's a holdover that's actually in the property, deadbeats,
Right.
Try to say we can cut that out, but someone that's a brother or a sister that just doesn't want to vacate the property, they won't sign them. But after 15 days, it kind of gives the attorney the ability to say to the court, like, hey, they didn't sign this, so we can move on. So.
Yeah, I mean, we've had to deal with evictions too, so
I'm dealing with 2 right now.
There you go.
Yeah. Some people just don't want to leave, and no matter what you do. I try to explain to them that, more it's coming out of the state funds, the more you do not participate, go along with the process of the probate process. You're just taking more money from the state. Now you have to hire an eviction attorney, which is a whole nother process, lengthy process, and expensive.
Right. Yeah. So if it's the beneficiaries that are in their home, hopefully they have their own vested interest. So
yeah. If there's insurance policies or retirement accounts, investment accounts, is that your responsibility to gather that information, or is it the actual personal representative to gather that and then distribute it? Who distributes all those assets?
So ultimately, it's the personal representative. So the personal representative is the one who's talking to the banks, is talking to the mortgage companies, talking to all of the individual entities. And then ultimately, once we get approval from the court, then the personal representative is the one making the distribution themselves. So we don't actually personally talk to them directly unless we're helping the client. Then, there are times that we will talk with them if they're not doing something they're supposed to do. But beyond that, the personal representative is the one who has that contact and is making the final decision.
What are the common mistakes you see personal representatives make as they're going through probate? What do they do intentionally or non-intentionally that could stop the probate or just drag on?
Usually, a lot of times, it's just mismanagement of money. They don't know, or they think they can do something with the money, but then they can't. And usually, it's dealing with just small things like that. Everything is usually correctable as long as they didn't do it intentionally or they're not trying to take the money. So usually, things like that can be fixed. But I would say that's probably the largest one that I see most prevalently.
And that EIN number, that helps you open up an estate account, and all the assets, every single dollar should go into that estate account, correct? And be accounted for.
Correct. Yes.
No commingling, right?
Correct.
Have you seen commingling before?
I've seen commingling. Yes. And we're like, no, didn't you open up another account like I told you?
Yeah.
No, I just put it in my other account. No, take it back out.
Yeah. Let's go back here. Would a judge, if you have other beneficiaries and you are commingling, that's a big no-no.
Right.
But what I've seen too is like if you're the only beneficiary, the only child, I've seen a lot of kind of leeway where they do kind of commingle sometimes. And do they get away with it? I mean, or does the judge want to see all the assets go into that estate account?
Well, they have to rectify it, but there's no one there to object. So usually the people the reason why we find out that people are commingling funds is because it's a beneficiary who's like, I want to see an accounting. What are you doing with the money? And so usually when they petition to have an accounting, that's when we find out, hey, you're not using the funds correctly. And that's usually a lot of times they'll remove the personal representative and they'll appoint somebody else.
The judge will actually do that if you're not doing what you need to be doing.
Yeah, if the person objects and petitions for it, yes, absolutely.
Lineage, right? So you pass away, mom or dad, or they're the ones left. Who would be next in line to petition the court to be the personal representative? And who would the court mostly grant to do so?
So if the person who passed away have a spouse, the spouse gets first dibs. If the spouse doesn't want to, she can appoint somebody else, and the court will usually go with whoever that person is. If there is no spouse, they'll look to the children. If there's no children, then they'll look to the brother and sisters. And if there's none of them, then we're just looking for anyone else who will petition that nobody objects to.
We'll go back here. Talk to me a little bit about when you first started in law. I know you did employment law. Is that correct?
Yes, I do employment law.
Tell me about that and what that entails.
Right. So I represent the plaintiff, so the injured worker, against the employer for a number of things that they can allege, whether it's harassment, discrimination, sexual harassment, any litany of things against the employer. Yep.
What's business law, and what in your particular field? What do you actually specialize in business law? Because it's so broad.
Right. So it would be business litigation, business contracts, and business formation.
Interesting. And you guys do actually real estate law too as well, or is it something that you guys, is that entailed in the business law, or is that something
on the contract side? So if it was a contract issue, then yes. But other nuances of real estate law, like construction defects, we don't handle that.
None of that. Well, how long have you been an attorney? How long has this path for you? How long has this been for you?
I'm going on my 4th year.
Oh, wow. That's great. That's fantastic. Talk to me a little bit about your background beforehand. You said before we started filming, you were actually had a whole nother life.
Yes, I had a whole nother life before I was an attorney. That's why I'm only going on my 4th year. I did almost 10 years in accounting and finance. And so I was a corporate controller for some time. And I wasn't going to be an attorney, even though I got my law degree. But ultimately, one day, I made the switch, and I don't regret it ever since. So that's why I have that financial background as well.
Good for you. If someone wants to get a hold of you to get an estate plan, or they want to contact you for business law or employment law, they need help. What's a great way to contact you in your office? Good number to do.
Yeah, absolutely. So our office line is 916-957-5840. And somebody will answer the phone, whether it's Ashley in the office or Clarissa or myself. And then we'll set up a consultation with you. And hopefully we can kind of get your life more financially organized. So usually we send out a type of questionnaire for us to realize what's most important to you, so you can let us know. And you'll also, at that point, be able to gather all those documents to kind of put together what your asset picture looks like, and it'll give us a good idea of how to proceed forward. So again, it's just, if you reach out to us, we do free consultations, and we're more than happy to sit down with you and kind of make sure that you have the right plan in place for what you need.
You're really big on education, right? So you're always going throughout the county, multiple counties, and just educating people. And that's kind of one of your big things that you feel people need more education in terms of just anything like estate law, business law, all this stuff. So when is the next, when possibly might be the next seminar that you might throw out there?
Oh, there's one tonight.
Oh, there you go. There you go.
Yeah, we have a seminar tonight. It's by one of our other attorneys, Felicia, and she's doing the presentation on estate planning and educating the public there. We have another one in Folsom. The one tonight is in Sacramento. We have another one in Folsom next month. Oh, I don't know the exact date off the top of my head, but again, we try to reach out to the different communities in order to spread awareness and education regarding estate planning and the benefits of it.
What's your website? What's your website so people go to? I know people are always online, and that's probably one of the best ways to contact you. What's your website?
Right. So our website is www.yoestlaw.com.
There you go. Well, it was nice having you today. I really appreciate you coming on in. I've learned a lot. And thank you so much for being here. Nice to have you.
Thank you for asking me to be here. I appreciate it.
Yeah, thank you so much. My hands are cold.
No worries.